In the law of evidence, documents play an important role in proving facts before a court. When a party wants to prove the contents of a document, the law prefers the production of the original document. This is known as primary evidence. However, in certain situations, the original document cannot be produced. In such cases, the law allows secondary evidence. Meaning of primary evidence. Primary evidence means the original document itself produced before the court for inspection. In simple words, primary evidence is the best and most reliable evidence of a document because it is the original document. Examples: original sale deed, original agreement, original will, original receipt. If the original document is available, it should normally be produced before the court. Importance of primary evidence. It is the most reliable form of documentary evidence. It minimizes the possibility of fraud or alteration. It enables the court to examine the original document directly. The law generally requires documents to be proved by primary evidence. Meaning of secondary evidence. Secondary evidence means evidence that is given in place of the original document when the original cannot be produced for a valid reason. It is not the original document but a substitute permitted by law. Examples of secondary evidence: certified copies, photocopies, copies made from the original by mechanical process, counterparts of documents, oral accounts of the contents of a document by a person who has seen it. Important rule: secondary evidence is not automatically admissible. It can be used only in situations recognized by law. Cases in which secondary evidence may be given: 1. When the original is in possession of the opposite party. If the original document is with the opposite party, and that party fails to produce it after receiving proper notice, secondary evidence may be given. Example: a contract is in B's possession. After receiving notice, B refuses to produce it. A may then produce a copy. 2. When the original has been lost or destroyed. If the original document has been lost, destroyed, or cannot be found despite reasonable efforts, secondary evidence is admissible. Example: a fire destroys an original sale deed. A certified copy may be produced. 3. When the original cannot be produced for reasons beyond control. Sometimes the original exists but cannot be produced within a reasonable time due to circumstances beyond the control of the party. Example: the document is located in a distant foreign country and cannot be obtained immediately. 4. When the original is a public document. Public documents are generally proved by certified copies. Examples: birth certificates, revenue records, court records, government records. 5. When certified copies are permitted by law. Certain laws expressly permit proof by certified copies. Example: certified copies of registered documents. 6. When originals consist of numerous documents. If a fact is to be proved from a large number of documents that cannot conveniently be examined in court, a summary prepared by a competent person may be produced. Example: large business accounts running into thousands of entries. Case study: simple language. Lost sale deed case. Ram purchased a piece of land and received an original sale deed. Several years later, a dispute arose regarding ownership of the land. Before filing the case, Ram discovered that the original sale deed had been destroyed in a flood. Ram obtained a certified copy from the registration office and produced it before the court. The court accepted the certified copy as secondary evidence because the original document had been destroyed. The loss was genuine. The certified copy was obtained from an official source. The court relied on the certified copy and decided the case. Lesson from the case. When an original document is genuinely unavailable, the law does not deny justice. It allows secondary evidence under proper safeguards.